conjunction with Article 36, Paragraph 1 of the Statute of the Court. Article 9 of the Genocide Convention reads as follows, I quote, "Disputes between contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute." End of quote. The Gambia and Myanmar are parties to the Genocide Convention. Myanmar deposited its instrument of ratification on 14 March 1956 without entering a reservation to Article 9, but making reservations to Articles 6 and 8. The Gambia acceded to the Convention on 29 December 1978 without entering any reservation. Myanmar raises 4 preliminary objections to the jurisdiction of the court and the admissibility of the application. In its first preliminary objection, Myanmar argues that the court lacks jurisdiction, or alternatively, that the application is inadmissible on the ground that the real applicant in this proceeding is the Organization of Islamic Cooperation, to which I shall refer as the OIC. According to the second preliminary objection, the applicant is inadmissible because the Gambia lacks standing to bring this case. Myanmar asserts in its third preliminary objection that the court lacks jurisdiction or that the application is inadmissible because the Gambia cannot validly seize the court in light of Myanmar's reservation to Article 8 of the Genocide Convention. In its fourth preliminary objection, Myanmar contends that the court lacks jurisdiction, or alternatively that the application is inadmissible because there was no dispute between the parties under the Genocide Convention on the date of the filing of the application. The court notes that when deciding on preliminary objections, it is not bound to follow the order in which they are presented by the respondent. In the present case, the court will start by addressing the first preliminary objection relating to the real applicant in the case, before turning to the fourth preliminary objection on the existence of a dispute, and to the third preliminary objection concerning Myanmar's reservation to Article 8 of the Genocide Convention. Finally, the court will deal with the second preliminary objection pertaining to the standing of the Gambia, which presents a question of admissibility only. As to the first preliminary objection, Myanmar argues that the court lacks jurisdiction, or alternatively that the application is inadmissible because the real applicant in the proceeding is the OIC, an international organization, which cannot be a party to proceedings before the court pursuant to Article 34, Paragraph 1 of the Statute of the Court. The court will first examine the question of its jurisdiction. The court establishes its jurisdiction ratio personae on the basis of the requirements laid down in the relevant provisions of its statute and the Charter of the United Nations. Pursuant to Article 34, Paragraph 1 of the statute, only states may be parties to cases before the court. According to Article 35, Paragraph 1 of the statute, the court shall be open to all states parties to the present statute. Article 93, Paragraph 1 of the Charter of the United Nations provides that all members of the United Nations are ipso facto parties to the statute of the International Court of Justice. The Gambia has been a member of the United Nations since 21 September 1965 and is ipso facto a party to the statute of the court. The court therefore considers that the Gambia meets the aforementioned requirements. Myanmar submits, however, that in bringing its claims before the court, the Gambia has in fact acted as an organ, agent, or proxy of the OIC, which is the true applicant in these proceedings. Its main contention is that a third party, namely the OIC, which is not a state, and cannot therefore have a reciprocal acceptance of jurisdiction with the respondent state, has used the Gambia as a proxy in order to circumvent the limits of the court's jurisdiction ratio personae and invoke the compromissory clause of the Genocide Convention on its behalf. The court notes that the Gambia instituted the present proceedings in its own name as a state party to the statute of the court and to the Genocide Convention. It also notes that the Gambia's assertion that it has a dispute with Myanmar regarding its own rights as a state party to the Convention. The Court observes that the fact that a state may have accepted the proposal of an intergovernmental organization of which it is a member to bring a case before the Court, or that it may have sought and obtained financial and political support from such an organization or its members in instituting these proceedings, does not detract from its status as the applicant state before the Court. Moreover, the question of what may have motivated a state such as the Gambia to commence proceedings is not relevant for establishing the jurisdiction of the Court. With regard to Myanmar's argument that the approach taken by the Court to establish the existence of a dispute shall be followed in cases where the identity of a real applicant is at issue, the Court is of the view that these are distinct legal questions. In the present case, the Court sees no reason why it should look beyond the fact that the Gambia has issued proceedings against Myanmar in its own name. The Court is therefore satisfied that the applicant in this case is the Gambia. In light of the foregoing, the first preliminary objection raised by Myanmar, insofar as it concerns the jurisdiction of the Court, must be rejected. The Court then examines Myanmar's alternative argument that even if the Court were to find that it has jurisdiction, the Gambia's application would, in the circumstances, be inadmissible based on an abusive process or other grounds of inadmissibility. The Court has already found that the applicant in these proceedings is the Gambia, a state party to the statute of the Court and a party to the Genocide Convention, which confers on the Court jurisdiction over disputes between the contracting parties relating to the interpretation, application, or fulfillment of the Convention. As the Court has previously held, it is only in exceptional circumstances that the Court should reject a claim based on a valid title of jurisdiction on the ground of abusive process. The Court observes that no evidence has been presented to it showing that the conduct of the Gambia amounts to an abusive process. Nor is the Court confronted in the present case with other grounds of inadmissibility, which would require it to decline the exercise of its jurisdiction. Thus, the first preliminary objection of Myanmar, insofar as it concerns the admissibility of the Gambia's application, must be rejected. In light of the foregoing, the Court concludes that the first preliminary objection of Myanmar must be rejected. The Court then turns to the fourth preliminary objection, whereby Myanmar argues that the Court lacks jurisdiction, or alternatively that the application is inadmissible because there was no dispute between the parties on the date of the filing of the application instituting proceedings. The Court begins by recalling that the existence of a dispute between the parties is a requirement for the Court's jurisdiction under Article 9 of the Genocide Convention. According to the established case law of the Court, a dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between parties. In order for a dispute to exist, it must be shown that the claim of one party is positively opposed by the other. The two sides must hold clearly opposite views concerning the question of performance or non-performance of certain international obligations. The Court's determination of the existence of a dispute is a matter of substance and not a question of form or procedure. In principle, the date for determining the existence of a dispute is the date on which the application is submitted to the Court. However, conduct of the parties subsequent to the application may be relevant for various purposes, in particular to confirm the existence of a dispute. The Court has also previously held that in making such a determination, it takes into account, in particular, any statements or documents exchanged between the parties, as well as any exchanges made in multilateral settings. In so doing, it pays special attention to the author of the statement or document, their intended or actual addressee, and their content. In this regard, the Court notes that in the present case, there are 4 relevant statements made by representatives of the parties before the United Nations General Assembly in September 2018 and September 2019. These statements were made during the 2018 and 2019 general debates of the Assembly, which took place in the weeks following the publication of 2 reports by the fact-finding mission on Myanmar established by the Human Rights Council of the United Nations, on 12 September 2018 and on 8 August 2019, respectively. Also relevant to the determination of the existence of the dispute is the note verbal that the Gambia sent to the Permanent Mission of Myanmar to the United Nations on 11 October 2019. In its first report, dated 12 September 2018, the fact-finding mission stated, I quote, "The crimes in Rakhine State and the manner in which they were perpetrated are similar in nature, gravity, and scope to those that have allowed genocidal intent to be established in other contexts." End of quote. On that basis, the fact-finding commission concluded that there was sufficient information, I quote, "to warrant the investigation and prosecution of senior officials of the Tatmadaw chain of command so that a competent court can determine their liability for genocide in relation to the situation in Rakhine State," end of quote, and called upon the international community through the United Nations to use all peaceful means to assist Myanmar in meeting its responsibility to protect its people from genocide. The fact-finding mission reiterated the statements in the detailed findings version of the same report published on 17 December 2018, where it noted that the Myanmar authorities have demonstrated that they were unable and unwilling to meaningfully engage in the process of investigating and prosecuting crimes under international law, and that consequently the impetus for accountability must come from the international community. A copy of the report was shared with the government of Myanmar prior to its release. On 25 September 2018, the President of the Gambia, Mr. Adama Barrow, stated in his address to the General Assembly that as the upcoming chair of the next summit of the OIC, the Gambia, I quote, had undertaken through a resolution to champion an accountability mechanism that would ensure that the perpetrators of the terrible crimes against the Rohingya Muslims are brought to book, end of quote. In a speech delivered 3 days later in the same session of the General Assembly, Myanmar's Union Minister for the Office of State Counselor, Mr. Kya Tint Swe, expressed Myanmar's serious concern over the report of the fact-finding mission and rejected its findings as, I quote, "based on narratives and not on hard evidence," end of quote. In its second report, published on 8 August 2019, the fact-finding mission stated that it had reasonable grounds to conclude inter alia that Myanmar incurs state responsibility under the prohibition against genocide and, I quote, "welcomed the efforts of states, in particular Bangladesh and the Gambia, and the Organization of Islamic Cooperation to encourage and pursue a case against Myanmar before the International Court of Justice under the Convention on the Prevention and Punishment of the Crime of Genocide," end of quote. The fact-finding mission repeated these statements in the detailed findings version of the same report, published on 16 September 2019, and added that, I quote, "Myanmar is failing in its obligation to prevent genocide, to investigate genocide, and to enact effective legislation criminalizing and punishing genocide," end of quote. A copy of this report was also provided to Myanmar. Following the publication of the second report and the detailed findings of the fact-finding mission, the Vice President of the Gambia, Ms. Isatou Touré, in an address to the General Assembly on 26 September 2019, stated that, I quote, "As a global community with a conscience, we cannot continue to ignore the plight of the Rohingya," end of quote, and declared her government's intention to, I quote, "lead concerted efforts to take the Rohingya issue to the International Court of Justice on behalf of the Organization of Islamic Cooperation," end of quote. 2 days after the address by the Gambia, Myanmar's Union Minister for the Office of State Counselor, Mr. Kra Tint Swe, stated before the General Assembly that the fact-finding mission's reports, I quote, "without exception, have been biased and flawed, and that the latest reports are even worse," end of quote. Myanmar contests the existence of a dispute between the parties on 2 grounds. First, Myanmar argues that the statements made in the General Assembly and the note verbal sent by the Gambia on 11 October 2019 lacked sufficient particularity in the sense that the Gambia did not specifically articulate its legal claims. Secondly, Myanmar maintains that the requirement of mutual awareness is not satisfied because it had never rejected specific claims by the Gambia. The Court will now examine these two grounds advanced by Myanmar to contest the existence of a dispute between the parties. With regard to Myanmar's argument that the existence of a dispute requires what Myanmar refers to as mutual awareness by both parties of their respective opposed positions, the conclusion that the parties hold opposite views concerning the performance or non-performance of legal obligations does not require that the respondent must expressly oppose the claims of the applicant. If that were the case, a respondent could prevent a finding that a dispute exists by remaining silent in the face of an applicant's legal claims. Such a consequence would be unacceptable. It is for this reason that the Court considers that in case the respondent has failed to reply to the applicant's claims, it may be inferred from its silence in certain circumstances that it rejects those claims and that, therefore, a dispute exists at the time of the application. Consequently, the Court is of the view that the requirement of mutual awareness based on two explicitly opposed positions, as put forward by Myanmar, has no basis in law. Turning to Myanmar's argument that the statements made by the Gambia before the United Nations General Assembly lacked sufficient particularity, the Court notes that those statements did not specifically mention the Genocide Convention. The Court, however, does not consider that a specific reference to a treaty or to its provisions is required in this regard. As the Court has affirmed in the past, however, I quote, "The exchanges between the relevant states must refer to the subject matter of the treaty with sufficient clarity to enable the state against which the claim is made to identify that there is or may be a, quote, a dispute with regard to that subject matter." End of quote. In this context, the Court notes that the statements of the Gambia in September 2018 and September 2019 were made shortly after the publication of the fact-finding mission's reports. The 2018 report specifically alleged that the perpetration of crimes in Rakhine State that were similar in nature, gravity, and scope to those that have allowed genocide intent to be established in other contexts, while the 2019 report specifically referred to Myanmar's responsibility under the Genocide Convention. The Gambia was undoubtedly referring in its statement to the findings of these reports, which were a key United Nations report on the situation of the Rohingya population in Myanmar, and which had been referred to in various reports that were before the General Assembly. In particular, the second report of the fact-finding mission identified the Gambia as one of those states making efforts to pursue a case against Myanmar before the Court under the Convention. Myanmar could not have been unaware of this fact. Similarly, Myanmar's rejection of the findings of these reports demonstrates that it was positively opposed to any allegations of genocide being committed by its security forces against the Rohingya communities in Myanmar, as well as to the allegation of its responsibility under the Genocide Convention for carrying out acts of genocide. Such allegations were contained in the two reports and publicly taken up by the Gambia. The Court considers that the statements made by the parties before the United Nations General Assembly in 2018 and 2019 indicate the opposition of their views on the question whether the treatment of the Rohingya group was consistent with Myanmar's obligations under the Genocide Convention. Myanmar could not have been unaware of the fact that the Gambia had expressed the view that it would champion an accountability mechanism for the alleged crimes against the Rohingya following the release of the fact-finding mission's report of 2018. Moreover, Myanmar could not have failed to know of the announcement by the Vice President of the Gambia before the General Assembly during the general debate in September 2019 that her government intended to lead concerted efforts to take the Rohingya issue to the court. It was the Gambia, and the Gambia alone, that had expressed such an intention before the General Assembly in 2019. The statements made in both 2018 and 2019 before the General Assembly by Myanmar's Union Minister for the Office of the State Councillor expressed views of his government which were opposed to those of the Gambia's and clearly reject the reports and findings of the fact-finding mission. Moreover, the note verbal sent by the Gambia to the permanent mission of Myanmar to the United Nations on 11 October 2019 brought clearly into focus the positive opposition of views between the parties by expressing specifically and in legal terms the Gambia's position concerning Myanmar's alleged violations of its obligations under the Genocide Convention. The court further notes that Myanmar never responded to this note verbal. As was previously held by the court, the positive opposition of the claim of one party by the other need not necessarily be expressis verbis. The position or the attitude of a party can be established by inference, whatever the professed view of that party. In particular, the existence of a dispute may be inferred from the failure of a state to respond to a claim in circumstances where such a response is called for. The question whether such an inference may be drawn depends on the particular circumstances of each case. The court recalls that Myanmar was informed through the reports of the fact-finding mission of 2018 and 2019 of the allegations made against it concerning violations of the Genocide Convention. It also had an indication of the Gambia's opposition to its views in this matter, as reflected in statements by the representatives of the Gambia and Myanmar before the United Nations General Assembly. Thus, the note verbal did not constitute the first time that these allegations were made known to Myanmar. In light of the nature and gravity of the allegations made in the Gambia's note verbal and Myanmar's prior knowledge of their existence, the court is of the view that Myanmar's rejection of the allegations made by the Gambia can also be inferred from its failure to respond to the note verbal within the 1-month period preceding the filing of the application. In light of the foregoing, the court concludes that a dispute relating to the interpretation, application, and fulfillment of the Genocide Convention existed between the parties at the time of the filing of the application by the Gambia on 11 November 2019. The fourth preliminary objection of Myanmar must therefore be rejected. The court then turns to the third preliminary objection, in which Myanmar submits that the court lacks jurisdiction or that the Gambia's application is inadmissible because the Gambia cannot validly seize the court under the Genocide Convention. In Myanmar's view, this is the effect of its reservation to Article 8 of the Genocide Convention. Myanmar's third preliminary objection raises the question of the season of the court. For the purpose of ascertaining whether Article 8 governs the season of the court will have recourse to the rules of customary international law on treaty interpretation, as reflected in Articles 31 to 33 of the Vienna Convention on the Law of Treaties of 23 May 1969, to which I shall refer as the Vienna Convention. The court observes that the ordinary meaning of the expression competent organs of the United Nations, viewed in isolation, could appear to encompass the court, the principal judicial organ of the United Nations. However, reading Article 8 as a whole leads to a different interpretation. In particular, Article 8 provides that the competent organs of the United Nations may take such action as they consider appropriate, which suggests that these organs exercise discretion in determining the action that should be taken with a view to, quote, the prevention and suppression of the acts of genocide or any other acts enumerated in Article 3, end of quote. The function of the competent organs envisaged in this provision is thus different from that of the court, whose function is to decide, in accordance with international law, such disputes as are submitted to it pursuant to Article 38, Paragraph 1 of its statute, and to give advisory opinions on any legal question pursuant to Article 65, Paragraph 1 of its statute. In this sense, Article 8 may be seen as addressing the prevention and suppression of genocide at the political level rather than as a matter of legal responsibility. Furthermore, pursuant to customary international law as reflected in Article 31 of the Vienna Convention, the terms of Article 8 must be interpreted in their context and in particular in light of other provisions of the Genocide Convention. In this regard, the Court pays specific attention to Article 9 of the Genocide Convention, which constitutes the basis of its jurisdiction under the Convention. In the Court's view, Articles 8 and 9 of the Genocide Convention have distinct areas of application. Article 9 provides the conditions for recourse to the principal judicial organ of the United Nations in the context of a dispute between contracting parties, whereas Article 8 allows any contracting party to appeal to other competent organs of the United Nations, even in the absence of a dispute with another contracting party. It follows from the ordinary meaning of the terms of Article 8, considered in their context, that provision does not govern the season of the court. In light of this finding, the Court is of the view that there is no need to resort to supplementary means of interpretation, such as the travaux préparatoires of the Genocide Convention. Given that Article 8 does not pertain to the season of the court, Myanmar's reservation to that provision is irrelevant for purposes of determining whether the court is properly seized of the case before it. Consequently, it is not necessary for the court to examine the content of Myanmar's reservation to Article 8. The court therefore concludes that Myanmar's third preliminary objection must be rejected. Finally, the court examines the second preliminary objection, by which Myanmar submits that the Gambia's application is inadmissible because the Gambia lacks standing to bring the case before the court under Article 9 of the Genocide Convention. In particular, Myanmar considers that only injured states, which Myanmar defines as states adversely affected by an internationally wrongful act, have standing to present a claim before the court. In Myanmar's view, the Gambia is not an injured state and has failed to demonstrate an individual legal interest. Myanmar further submits that the Gambia's claims are inadmissible insofar as they are not brought before the court in accordance with the rule concerning nationality of claims. Finally, Myanmar maintains that even if contracting parties that are not specially affected by an alleged violation of the Convention are assumed to have standing to submit a dispute to the court under Article 9, this standing is subsidiary to and dependent upon the standing of states that are specially affected. Myanmar argues that Bangladesh would be the most natural state to institute proceedings in the present case because it borders Myanmar and has received a significant number of alleged victims of genocide. In Myanmar's view, the reservation by Bangladesh to Article 9 of the Genocide Convention not only precludes Bangladesh from bringing a case against Myanmar, but it also bars any non-injured state, such as the Gambia, from doing so. The question to be answered by the court is whether the Gambia is entitled to invoke Myanmar's responsibility before the court for alleged breaches of Myanmar's obligations under the Genocide Convention. The court recalls the advisory opinion on reservations to the Convention on the Prevention and Punishment of the Crime of Genocide, in which it explained the legal relationship established among states parties under the Genocide Convention. I quote, "In such a convention, the contracting states do not have any interests of their own. They merely have, one and all, a common interest, namely, the accomplishment of those high purposes which are the raison d'etre of the convention. Consequently, in a convention of this type, one cannot speak of individual advantages or disadvantages to states, or of the maintenance of a perfect contractual balance between rights and duties. The high ideals which inspired the Convention provide, by virtue of the common will of the parties, the foundation and measure of all of its provisions." End of quote. All the states parties to the Genocide Convention thus have a common interest to ensure the prevention, suppression, and punishment of genocide by committing themselves to fulfilling the obligations contained in the Convention. As the Court has affirmed, such a common interest implies that the obligations in question are owed by any state party to all the other states parties to the relevant convention. They are obligations erga omnes partes, in the sense that each state party has an interest in compliance with them at any given case. The common interest in compliance with the relevant obligations under the Genocide Convention entails that any state party, without distinction, is entitled to invoke the responsibility of another state party for alleged breach of its obligations erga omnes partes. Responsibility for an alleged breach of obligations erga omnes partes under the Genocide Convention may be invoked through the institution of proceedings before the Court, regardless of whether a special interest can be demonstrated. If a special interest were required for that purpose, in many cases, no state would be in a position to make a claim. For these reasons, Myanmar's purported distinction between an entitlement to invoke responsibility under the Genocide Convention and standing to pursue a claim for this purpose before the Court has no basis in law. For the purpose of institution of proceedings before the Court, a state does not need to demonstrate that any victims of alleged breach of obligations erga omnes partes under the Genocide Convention are its nationals. The Court recalls that where a state causes injury to a natural or legal person by an internationally wrongful act, that person's state of nationality may be entitled to exercise diplomatic protection, which consists of the invocation of state responsibility for such injury. The Court further notes that the scope of diplomatic protection has been extended to include, inter alia, alleged violations of internationally guaranteed human rights. However, the entitlement to invoke the responsibility of a state party to the Genocide Convention before the Court for alleged breaches of obligations erga omnes partes is distinct from any right that a state may have to exercise diplomatic protection in favor of its nationals. The aforementioned entitlement derives from the common interest of all state parties in compliance with these obligations, and it is therefore not limited to the state of nationality of alleged victims. In this connection, the Court observes that victims of genocide are often nationals of the state allegedly in breach of its obligations erga omnes partes. The Genocide Convention does not attach additional conditions to the invocation of responsibility or admissibility of the claims submitted to the Court. The use of the expression "the contracting parties" in Article 9 is explained by the fact that the Court's jurisdiction under Article 9 requires the existence of a dispute between two or more contracting parties. By contrast, any contracting party may seek recourse before the competent organs of the United Nations under Article 8, even in the absence of a dispute with other contracting parties. Besides, the use of the word disputes as opposed to any dispute or all disputes in Article 9 of the Genocide Convention is not uncommon in compromissory clauses contained in multilateral treaties. Similarly, the terms of Article 9, providing that disputes are to be submitted to the Court at the request of any parties to the dispute, as opposed to any of the contracting parties, do not limit the category of contracting parties entitled to bring claims for alleged breach of obligations erga omnes partes under the Convention. This phrase clarifies that only a party to the dispute may bring it before the Court, but it does not indicate that such a dispute may only arise between a state party allegedly violating the Convention and a state specially affected by such alleged violation. It follows that any state party to the Genocide Convention may invoke the responsibility of another state party, including through the institution of proceedings before the Court, with a view to determining the alleged failure to comply with its obligations erga omnes partes under the Convention and to bringing that failure to an end. The Court acknowledges that Bangladesh, which borders Myanmar, has faced a large influx of members of the Rohingya group who have fled Myanmar. However, this fact does not affect the right of all other contracting parties to assert the common interest in compliance with the obligations erga omnes partes under the Convention, and therefore does not preclude the Gambia's standing in the present case. Accordingly, the Court does not need to address the arguments of Myanmar relating to Bangladesh's reservation to Article 9 of the Genocide Convention. For this reason, the Court concludes that the Gambia, as a state party to the Genocide Convention, has standing to invoke the responsibility of Myanmar for the alleged breaches of its obligations under Articles 1, 3, 4, and 5 of the Convention. Therefore, Myanmar's second preliminary objection must be rejected. I shall now read out the operative part of the judgment. For these reasons, the Court, 1, unanimously rejects the first preliminary objection raised by the Republic of the Union of Myanmar. 2, unanimously rejects the fourth preliminary objection raised by the Republic of the Union of Myanmar. 3, unanimously rejects the third preliminary objection raised by the Republic of the Union of Myanmar. 4, by 15 votes to 1, rejects the second preliminary objection raised by the Republic of the Union of Myanmar. In favor, President Donahue, Vice President Gevorgyan, Judges Tomka, Abraham, Benuna, Yusuf, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Judges Ad hoc, Pillay, Kress. Against, Judge Shui. By 15 votes to 1, finds that it has jurisdiction on the basis of Article 9 of the Convention on the Prevention and Punishment of the Crime of Genocide to entertain the application filed by the Republic of the Gambia on 11 November 2019, and that the said application is admissible. In favor, President Donahue, Vice President Gevorgyan, Judges Tomka, Abraham, Benuna, Yusuf, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Judges Ad hoc Pillay, Kress. Against, Judge Shui. I shall now call upon the Registrar to read the operative part of the judgment in French.
Par ces motifs, la Cour, 1. À l'unanimité, rejette la première exception préliminaire soulevée par la République de l'Union du Myanmar. 2. À l'unanimité, rejette la quatrième exception préliminaire soulevée par la République de l'Union du Myanmar. 3. À l'unanimité, rejette la troisième exception préliminaire soulevée par la République de l'Union du Myanmar. 4. Par 15 voix contre 1, rejette la deuxième exception préliminaire soulevée par la République de l'Union du Myanmar pour Madame Nonoyou, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, juge, Madame Pillay, Monsieur Kress, juge ad hoc. Contre, Madame Chouet, juge. 5. Par 15 voix contre 1, dit qu'elle a compétence sur la base de l'article 9 de la Convention pour la prévention et la répression du crime de génocide pour connaître de la requête introduite par la République de Gambie le 11 novembre 2019 et que la dite requête est recevable pour Madame Donoyou, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, juge, Madame Pillay, Monsieur Kress, juge ad hoc. Contre, Madame Chouet, juge.
Judge Shui appends a dissenting opinion to the judgment of the Court. Judge Ad hoc Kress appends a declaration to the judgment of the Court. The text of the judgment is available from today in TypeScript It will also be available shortly on the court's website. The printed text will be available in the near future. As the court has no other business before it, I declare the sitting closed.